So, you've recently come out with your opinion regarding the elevation, rather non-elevation, of Justice S. Muralidhar, who was one of the top best High Court judges that the country has seen, who was not brought to the Supreme Court. What was the reason for you to ask this question of the Supreme Court regarding Justice Muralidhar's elevation?
It was not to bring the Supreme Court into a bad light. That was not the intention. The intention was to give a wider perspective to this method of appointing judges or not appointing judges from the High Courts to the Supreme Court. Because that has been always a source of complaint, of anguish of various people. But let me go back to the beginning. You see, it was 35 years ago when the United Nations set out a set of basic principles for the independence of the judiciary. It was decided by the General Assembly unanimously. There was no dissent at all. And they said every country has to make its own constitution and decide according to its constitution what the position should be. But there are some minimum requirements. And the minimum requirement is that there should be a judiciary which is independent, decides independently, and manned by persons of integrity. Now, we have fulfilled all those norms. There is no doubt about it in our constitution. The article itself says. But in order to safeguard the question as to how people should be appointed, everywhere in the world, they are only appointed by the executive, whether you like it or not. But it has to be in consultation with the Chief Justice.
Is the question on the independence of the judiciary itself at this point?
At the moment, yes, the way it has worked out. You see, each country has its own background. Each country has its own background, how it has worked out. In the first 10 years or 15 years of the Constitution, there was no difficulty. In fact, statistics show that almost in all cases except one or two, the opinion of the Chief Justice of India, and that was the only requirement, the opinion of Chief Justice of India should be final. And that happened to be the practice right through for about 10 to 12 or 13 or 14 or 15 years. But then came the judgment in one of the judges' cases where by a majority they decided that according to the text of the Constitution, it said in consultation with the Chief Justice. It doesn't mean with the concurrence of the Chief Justice. And that was the controversy. So by a majority of 4 to 3, they said that no, it is the executive which will appoint. And without, whether in consultation, but not certainly not with concurrence. And then the trouble that arose was, as you know, next 10 years, 20 years, that judges were, that the executive then assumed that it was entitled to appoint whomsoever they please, which became another problem.
But the trouble that was happening at that time, the dissatisfaction amongst the judiciary and the government, was also because the judiciary was trying to be fiercely independent.
Yes.
And they were trying to ensure that the judges that they
Absolutely, because that is in consonance with the United Nations general principle.
Correct. So what is the situation that's different now, do you think?
No, you see, what is different now is that there was, having regard to the background, we had a judgment of 9 judges which said ultimately that no, the ultimate choice of the person to be appointed, whether as a High Court judge, person to be transferred from a High Court judge from one High Court to another, person to be appointed as Supreme Court judge, would be ultimately decided in consultation with government, but the ultimate choice will have to be not by not of the Chief Justice, but of the first 3 judges of the Supreme Court, which was later altered to the first 5.
Right. But what do the judges do when the government just sits on the recommendations endlessly? I mean, earlier also regarding certain High Court judges, we saw that recommendations were made, they reiterated them, they gave out very detailed collegium resolutions, but the government just did not move.
You see, this has happened on 2 occasions with 2 separate governments. It has happened with the Congress government. It has happened with the BJP, the NJD government, and again with the super majority BJP government. No difficulty at all. They all behave in the same way. Generally, they do follow. Generally, they do follow, but not always. But now, the present interview and the present arises because of that article which appeared yesterday or the day before. Right. And that article only goes to show that sometimes this happens. It's a rare case, but it's a very important case. A man who is of outstanding ability, who is overlooked, not only overlooked when he retires at 62, but a lot of other people who are get appointed to the highest court, and this man is left out without any explanation at all. Now, whether there should be an explanation, there should not be an explanation, to whom should that explanation be given, these are all matters to be thought of. They are all matters to be debated. It's not as if one is carping at the Supreme Court decision. They have to consider this. But my own view has always been that it is not the job of judges to judge judges. It is a job of judges to judge cases. And they do it pretty well in our country. They have done it pretty well for the last 70 odd years, with a few exceptions here and there, but they have all been got ironed out from court to court. So I still personally feel that there should be a national commission for appointment of judges and for transfer of judges. But the dominant voice should be with the 3 senior most or 5 senior most judges of the Supreme Court. It can't be otherwise. And that is why the Venkatachalaya Commission recommendations should have been accepted. They were accepted. A bill was passed in 2003. But unfortunately that bill lapsed, not because there was opposition, but because the elections were called. That's the only reason.
In your autobiography, you've also written about how such arbitrary transfers was something that was happening at the time of the emergency.
Oh yes, the emergency was terrible, yes.
So when it
was much worse. The emergency can't compare. People compare the present state of affairs with the emergency. I don't agree at all. The emergency was something much worse, and I know, I lived through the emergency. I resigned during the emergency. So I know exactly how the emergency worked. And it was something atrocious, much worse.
But when it comes to the aspect of judicial appointments, do you think the Supreme Court judges, the collegium, the 5 judges to decide this, have now, by not recommending Justice Muralidhar, have subscribed to the government's point of view, and they are not standing up?
So it appears. We can't say definitely, because nobody knows what. We are not party to the confabulations that took place. So it's for them to, whether to assert it or not assert. So quite frankly, I don't agree with the title of my article also, because that was put in by the editor. But in any case, as to the question for the Supreme Court to answer, they don't have to answer anybody. I quite agree. They don't have to answer. But we have the right to say something about it.
But they also have to answer their own conscience at the end of the day.
That's correct. And somebody has to say something, but nobody is saying something. That's the problem. And here's a person, and this could happen again and again. It has happened once before. As I said the other day, Justice Pense, who was a very distinguished judge of the Bombay High Court, he later went as Chief Justice of Karnataka. He was just not brought up. And there is no explanation why he was not brought up. He was an outstanding judge. He cleared a lot of arrears in the Bombay High Court. Tremendous. And he was a man fit to become, by all accounts, that's sort of a consensus by everybody. And had a very good brain and a very good grasp of the subject, but somehow he didn't turn up.